Good morning, everyone. It's Wednesday, March 17th. Happy St. Patty's Day. It's 8:33 a.m. This is a meeting of Senate Natural Resources and Energy, and we are taking additional testimony related to S-102, an act relating to the regulation of agricultural inputs for, I'm sorry, I'm
not ready to talk about that, Bill.
Yeah. No, I was going to say, wait, it's a pop quiz. It's a pop quiz. No, sorry.
On that one.
I'm off by one block on my own agenda here. So we're talking about, we don't have possession of the bill S-101, but we've been talking about sections 10 and 11 of S-101, which economic development passed out last week, and it's currently in finance. Meanwhile, it's still of interest to the committee, and so we've invited in today Mr. Ellers and Ms. Smith to talk to us about municipal waste systems and potable water and connections. So with that, Mr. Ellers, good morning. Thanks for coming in, and you're up first. So the floor is yours.
Good morning, Senator. Good morning, members of the Senate committee. Nothing like a little discussion around sewage with your morning coffee and tea. I have presented, you have an exhibits document, which I'm sharing. I believe Annette Smith is going to share the screen for us, which is really for reference because so many of you have outstanding background knowledge in this area. But I wanted to pull it all together in one place because there's been so much focus in Senate economic development, which I have listened to the testimony there, as well as your previous conversations. So with that in mind, there's Annette, if you could share. Okay, it's up there. Great, thank you. So for the record, my name is James Ellers. I'm a former commissioner with the New England Interstate Water Pollution Control Commission. I'm also the former chair of the Lake Champlain Citizens Advisory Committee on the future of Lake Champlain, as well as the former executive director of Lake Champlain International. So I have about 25 years worth of experience in this policy area. So Annette, if you could go to the next page. So here is our own Agency of Natural Resources public signage acknowledging the dangers to public health. You know, this just isn't an inconvenience. This is a public health threat that happens when our sewage treatment plants overflow. And there have been in the last, since 2015, since we passed a law requiring disclosure of overflows, there has been 179 million gallons of untreated human waste or partially treated human waste and untreated stormwater discharged and or diverted into our drinking water supplies and recreational waters. And as the DEC commissioner noted in Senate Economic Development, we're not alone. You know, this is an issue that all the states are facing, but I contend that for those of us that have knowledge, have a responsibility to address public health threats like this, and not just try to sweep them under the sewage plant, so to speak. Annette, the next slide. So wastewater, you know, there's all sorts of bad jokes, awful puns in this field of work. Wastewater is really composed of some nasty, nasty constituents. That is the reason why we have wastewater treatment to begin with. And even under good conditions, when our treatment plants are functioning firing on all 8 cylinders, the technology of our treatment plants in Vermont still has not kept pace with our economic system's desire to add more chemicals, compounds, and elements into our wastewater stream, and then therefore our drinking water supply. So we don't have a handle on how we're going to control PFAS. So any new connection means more PFAS into our drinking water supply. And what wasn't discussed in Senate Economic Development, but is just as important, is what do we do with all the sludge from these new connections? Even when treatment goes exceptionally well, there are still very nasty, dangerous constituents in our wastewater byproducts. So now, how do we get here from a legal standpoint? Like, why are we even talking about this? Annette, next slide. The federal government, in its wisdom, which I don't always say, but the federal government, in its wisdom, created the Anti-Degradation Policy. This is what we are compelled as a state to administer. You all can read, it's here for your reference for later, but in a nutshell, we are to be protecting existing uses as our waters are now, and we should not let them get worse. If we're going to let them get worse, there has to be a serious socioeconomic justification. And so that's a discussion I would welcome, both in this committee and in Senate Economic Development, about the actual economic justifications, because I haven't heard those made yet, and I'll get to that some more at the end. So now here's our law, rooted in the federal law, and many of you who are in the committee right now were in the Senate when Act 64, H35 as it was passed, the Vermont Clean Water Act. The Vermont Clean Water Act stipulates, mandates, it's not a may statement, it's a shall statement. The Secretary of Natural Resources shall apply the Anti-Degradation Implementation Policy to all new discharges that require a permit. Right now, we have 39 wastewater treatment plants in the state that have expired permits. And I don't think it's wise to leave this up to the municipalities. And the EPA certainly hasn't left it up to the municipalities. And you have not left it up to the municipalities. The Secretary, the Agency of Natural Resources. Again, for your reference, next slide, please. I've just included some of the highlights from the 38-page interim anti-degradation implementation procedure around those socioeconomic justifications and terms that get used frequently, assimilative capacity, cumulative impact. All of that's important because new connections aren't just new connections. They are cumulative impacts that affect the assimilative capacity. The town of Richmond does not have the staff to assess those issues were they to have sole authority on a new connection permit. Only the Agency of Natural Resources has that staff expertise in order to do that.
Mr. Ehlers, a quick question on that socioeconomic justification test. Where does that reside in law? Is that EPA and delegated to Vermont, or where are we looking?
Yes, and it's in our interim anti-degradation implementation procedure, which is referenced in 1251, section 1251A of Title 10, Chapter 47.
Okay, thank you.
There is another exhibit that details, again, just how poor the state of our water quality is. This was the driver for Act 64. All of the findings of Act 64 that are germane to this topic, I've excerpted and included on one page for your review. To me, the fact that 59% of the aquatic life in our lakes, 59% are not aquatic life are not fully supported and is reprehensible to me.
And can you explain that figure a little bit? Fully supported, what does that mean? It
means 41% of our lakes water quality is so poor that the ecosystem, the food web is compromised.
Uh-huh.
I mean, that's telling us that our ecological systems, they're not just on the verge of collapse, they are collapsing in some cases in the state of Vermont. Part of that reason is, and we had to pass law to do this. So, forgive me if I'm a little cynical or jaded at times about municipalities and their interest in protecting those of us downstream, as opposed to their zeal for growing their grand list. We had to pass a law in 2014, I believe it was, that required municipalities and DEC to tell us when there was human waste, untreated human waste in our rivers and streams and lakes, so as to not have our kids swimming in other people's sewage. It required a law. Here, we had to tell other Vermonters, you must disclose this. And so since then, this is what we've been able to aggregate for data. This is a project that I've been keeping track of at Lake Champlain International for the last 6 years, all of the sewage diversions and who they're coming from and what waters they're impacting. And I'm sure many of you realize that when water that's impacted, such as Otter Creek, is on the list, that it then flows into Lake Champlain. So we're talking, ultimately all this ends up in either the Connecticut River, Lake Memphremagog, or Lake Champlain, and to a very small portion, the Hudson River. But as you can see, is just one example. Rutland, with 454 diversions of sewage, 454. They're operating under an expired permit since 2008. Who's applying the anti-degradation policy? This is a total abdication of responsibility on the part of the state. Next slide, please. So all of this information that I've brought to you, that I will continue to bring to you, is all documented in the 303D list. The 303D list is, again, part of federal law. It's an EPA requirement that the state of Vermont and every state do an assessment and characterize the conditions of our water so that we can keep them, so that we can keep protecting them or remediate them as needed. So the hundreds of impaired waters that are mentioned previously in the Act 64 findings can all be referenced in some of these 303D lists. We're not meeting, for example, the requirements under our bacteria statewide TMDL, and that's the next slide, Annette. These are the segments of our rivers that have been impacted, and we've known they've been impacted prior to even September 2011, when the bacteria TMDL went into effect. We hear a lot about the Champlain phosphorus TMDL, but the bacteria TMDL is equally, in some cases, more important. But you can see that the city of Montpelier is impairing miles and miles and miles of river, and every new connection will only worsen that situation. St. Johnsbury, Vergennes, Rutland City. Next slide, please.
James, can I, Mr. Ellers, a quick question on that list. When, so these are all E. coli impairments. How do they measure? How do you get? Let me think of how to say it. How often do the streams have to be impaired to be on the list? I mean, does this mean this is a daily phenomenon, or if you had an event once a month, it would put you on the list? What's the threshold for making this list?
That is an excellent question. Rather than trying to recite the standard from memory, I would prefer to be able to send that to you.
Okay,
but,
sure.
Suffice it to say that it's a rather chronic situation when a waterway winds up on the impaired list, because all of our waterways at times experience spikes in E. coli levels for a host of reasons.
Right.
But these are waterways that are chronically impaired. due to poor infrastructure and lax regulation. You know, we heard from the commissioner of DEC. Well, I was listening in the Economic Development Committee when he said that rain doesn't cause pollution. That CSOs don't cause pollution. And to a certain extent, I agree with him. It's lax and irresponsible regulation that causes the pollution, but it's certainly not rain. Next slide, please. The literature, there are reams of literature on the health threats. That is why the CDC and the EPA have us treating our waste to begin with. This isn't just an ick factor. Very, very serious diseases can be transmitted through wastewater that ends up in our recreational waters. Whatever we don't pay for on the prevention side, we're going to pay for on the drinking water treatment side. So an ounce of prevention also applies in this case. So I leave this image here with you, again, to remind you that this isn't just some tree hugger issue. This is a public health imperative. And Annette, can you share the document entitled Solutions?
Give me a second. I got to see if I can find it. Okay, got it.
You know, while Annette's doing that, there's an interesting line on that signage, that blue signage that actually gets posted on the rivers. But unless you make your way to the discharge point, you never see that it says avoid swimming, wading, boating, or fishing after rainstorms. And so again, there is an inherent conflict of interest in municipalities telling people that the waters of their community are dangerous, particularly in a state so heavily dependent on tourism, particularly water-based recreation. Next slide, please.
I got it up, James.
Okay, excellent. Thank you.
Sorry, let me, sorry, just want to jump in. I had meant to offer this reminder up front. You may have noticed Senator Campion isn't with us this morning, and that's because he has a joint hearing with other committees on the Kern-Hatton School. So I just wanted to let people know he's interested. He'll be checking in later, but he's committed elsewhere. Thank you. Please go ahead. Thanks.
Excellent. Thank you, Senator. And Mr. Chair, this is my last document to share. I have a visual demonstration that I will leave up to your discretion as to whether you want to see it based on the amount of time we have, because I don't want to take away time from the other witness or from the senators asking of questions. But I do have a small little visual representation in case senators are still not convinced that new connections result in poorer water quality. So we're here to find solutions, though, not just to complain about the state of the world. And I know that the reason why this is in your committee, Senator, and members, is because you've been asked by your colleagues to look at wastewater issues because they're in your area of expertise. So let's give Senate Economic Development Committee some solutions. We heard from members in that committee that they were concerned about cost, that they were concerned about redundancy. Well, there are costs to keeping our waters clean. And those are costs that I think that should be fairly borne by developers, aspiring developers, landlords, et cetera. As to whether or not making ecological protections a secondary consideration in any way, shape, or form creates more affordable housing, there is no evidence I have seen to date presented by anyone that that is the case. we're expected to believe this as if it's a tenet of faith. Yes, bad pun intended. A tenet of faith that somehow or another, where we just need to rely on the altruism and generosity of developers, and they will pass the savings. The savings will trickle down to the rest of us. Have not seen any evidence of that. So how do we accomplish what the senators of economic development were looking to do? We can eliminate permit redundancy by eliminating local level permits. The towns don't have the expertise, they don't have the funds, they have an inherent conflict of interest. And after all, it is the agency that's required by federal law, not mayors and select boards. The ANR secretary and DEC commissioner explicitly, individually are legally responsible, not mayors and select boards, and replace municipal control, local government with local citizen oversight, and instill greater ANR accountability through a more robust Act 250 process. That addresses the permit redundancy issue. As far as creating affordable housing, something I desperately need, we need to focus on policies that directly assist my fellow Vermonters and not rely on people's personal altruism. The Senate Economic Development Committee could, I don't believe they have, take up rent stabilization, property tax reform, capital gains reform, stop paying people to move here to compete with us for our limited housing supply, halt the bulldozing of the affordable homes in the most expensive region of our state to subsidize the wealthiest entity in the world, the Department of Defense, so that the US Air Force can base a weapon system component of its nuclear arsenal in Burlington. We've bulldozed 200 homes, affordable homes, working class, middle class homes, as a direct subsidy to the Department of Defense. And lastly, pass a livable wage. I mean, that's one way to make housing affordable, is to make sure that people have the wages. I hear frequently developers talk about, well, we need a place for restaurant workers to live, to wait on us. They can't live 45 minutes away, and we can't address climate change if they're driving back and forth. Okay, well, pay them. Pay them, require, since again, altruism is not working, market forces continue to create income gaps and disparity and pollution. There are probably other ideas. I don't have all of the answers to this, but I think about this every single day. I have 4 young children. I live here. This is my vocation. I don't do it for the money, God knows. I do it because I believe we all have an obligation to leave a place better than which we found it. I thank you for your time. I appreciate the dedication of this committee to natural resources. I know it is frequently pitted against economic interest, and that is something we desperately have to change. Thank you, senators. I will reserve my visual demonstration if for a later point in the testimony, but I would like to end here and pass this to the next witness.
Okay, great. Thank you for the presentation, and thanks for your passion and energy in chasing down so much information on behalf of your fellow citizens. You're reminding me that I wrote to the Secretary of the Agency of Natural Resources this fall on the anti-deg rules, which have been languishing. So I will share that letter with you and the committee. I made a note to myself because that is part of the reason I wrote the letter, was to have a reminder to chase this one down from the off session into the on session. And now we're back, so it's the right time to follow up on that. Thank you.
Yes, and thank you for that. I'm very grateful. That was something you took the initiative on in testimony last year when we were dealing with Act 250. So thank you. Thank you for your diligence in following through. And I will stay on throughout the next witness's testimony in case there are any other questions.
Great. Thanks, Mr. Ellers. Ms. Smith, the floor is yours. Thank you.
Morning. Thank you to the committee for inviting me to testify. My name is Annette Smith. I'm Executive Director of Vermonters for a Clean Environment. And I very much appreciate this opportunity to testify. You don't need that window. Okay.
Could you be a little louder, please, Ms. Smith?
Can I? Is that better?
Yes.
Okay. Vermonters for a Clean Environment has worked on water issues, especially from 1999 to 2009. We were instrumental in driving the adoption of the groundwater protection law. We worked extensively on drinking water disinfection issues, including the Champlain Water District, Rutland, and leading to Grand Isle having the best and first granular activated carbon filtration system in the state. In 2008, we produced a report about ANR and water quality failures, and the 10th item is about anti-degradation and how the state has repeatedly failed to adopt it. This entire report really is about DEC and the failures in terms of water quality. And there's a little bit of other issues in here, but the anti-deg part of it, 2007, the legislature took note DEC had still failed to develop a policy and passed legislation 2008 requiring a final proposed rule in 2008. Well, we haven't seen that. And then you pass more legislation in 2015. They say they have a procedure, but that's not a rule. And I think Senator McDonald, you're chair of LCAR, you know what rules do. They come through for review. And we haven't had a public process that's enabled that. We also, in 2008, produced a book about water done with former wonderful photographer Ellen Powell. So what happened? In 2009, along came industrial wind and then solar. And we have not weighed in on water issues since. And the reason is because of what we have seen happen with our state agencies permitting things that I never in my lifetime in Vermont expected to see happen. For instance, with the Lowell Wind Project, where we did an investigation in 2016, we saw permits that allowed for the filling of hundreds of feet of Class A1 headwaters above 2,500 feet. On solar, we saw solar projects approved for Class 2 wetlands. Our experts in both cases brought in excellent information, and in both cases they were ignored. And everything that they said would happen happened, like all this sedimentation coming off of the solar site. And I've just become very jaded about our state's regulatory process where it concerns water quality protection. And these renewable energy project issues happened when the good guys were supposedly in charge at ANR. So now we come to S101 and sections 10 and 11, where the issue is enabling municipal hookups and that they can be approved multiple hookups rather than having it duplicated at the state level. And the assertion is that there is no connection between economic development, in particular for low-income housing, and the environment. But we cannot have a healthy economy without a healthy environment, and clean water is the key to the discussion about promoting smart growth and affordable housing in downtowns. So through testimony in your committee and in economic development, we've been told that Department of Environmental Conservation relies on municipalities regarding wastewater treatment facilities and their capacity, that the state permitting simply adds costs with no benefits except a technical engineering review of plumbing connections, and that the combined sewer overflows are caused by rain and aren't relevant to enabling multiple municipal hookups, and that enabling municipal permitting will free up money for wastewater treatment facilities to address combined sewer overflows. This raises issues about Vermont as a delegated state under the Clean Water Act, and the EPA's delegated this authority to the state of Vermont, not to municipalities. So has the EPA said it's okay for ANR's DEC to delegate this authority to municipalities. The discharges enter the waters of the state, not the waters of the municipalities. So I started looking at the NPDES permits. There are two websites. These are the discharge permits for the water treatment plants. There's a little inconsistency, and so I also found the EPA's website where you can look at everything. If you want to see an inconsistency, Brattleboro is one that stood out to me, which is why I went looking for a different one. So here's what I found. This is Rutland's sewage treatment plant discharge permit. The permit was issued in 2003. It expired in 2008. This means that there should have been, these are 5-year permits, there should have been the opportunity for the public to comment on a permit in 2008, in 2013, and in 2018. But there has been no opportunity because there is no updating of the permit. Now we go to Brandon, upstream. By the way, I live in the headwaters of the Otter Creek. I live in the area that has some of the purest water in the state. And so I care about what goes into the Otter Creek. This permit for Brandon issued 2007, expired 2011. Middlebury, we're going up the river towards Lake Champlain, issued 2008, expired 2013. Virgins, getting closer to the lake, issued 2005, expired 2009. Burlington, this is just one of Burlington's plants, issued 2005, expired 2010. We're seeing the wastewater treatment facility discharge permits from Rutland all the way up to Burlington have not been taken up, offered for public comment, reissued in some cases more than a decade. And just so you know, it's not exclusive to these areas. Bennington, expired 2016. Bethel, expired 2019, I think. Yeah, 2019. Some of these are under what's called a 1272 order. Rutland has a 1272 order. Virgins has a 1272 order. Burlington has a 1272 order. These are just some of the 1272 orders.
What is that? What is a 1272 order?
1272 order is under statute regulation of activities causing discharge or affecting significant wetlands. It's like getting an enforcement action. It requires setting out there's findings of fact, and then it requires setting out a whole sort of system for coming into compliance and fixing these problems. This is a non-transparent program. It is possible to find these 1272 orders, but it is not possible to find out what's happened with them because, like enforcement orders, they tend to go into the enforcement black hole. So there is a long-term control plan. I have no idea what's happened with this order. It was issued in 2018. And it supersedes one that was issued in 2012. So it appears to be kind of a chronic ongoing thing. You'd have to ask your commissioner more about these, because this is really all I know about them, is that these systems, all of which are impacting water quality in the Otter Creek and Lake Champlain, are out of compliance and don't have current permits. So EPA actually has a program and a strategy for reducing permit backlogs. And while they say that they're focused on the EPA issued permits, they're also assessing how it can assist NPDES authorized states with timely issue of permits. I hope,
Ms. Smith, can
yes.
I ask a very quick question? So
Sure.
when you have an expired permit for an EPD's permit, and then you have a 1272 order, do you know anything about, we'll have to follow up with council and with the ANR, but do you happen to know if the 1272 functions sort of as a de facto extension of your license? Like, okay, we didn't get our license, our NEPD's permit extended, but now we're operating under the 1272. Do you know
I don't
anything?
think that's the way it works. Does happen, and this happens, I've been finding this in other programs too. This particular permit is a 5-year permit. If a new application is filed timely, then it essentially extends the permit. I don't think anyone intended for permits to get extended for more than a decade. But I've seen this happening with air pollution. I've seen it happening with stormwater. I now would like to see an inventory of all the permits that DEC issues and how many of them are in this holding pattern. And my impression is that they are focusing on issuing new permits rather than bringing the old permits into compliance. But I find this very disturbing that all of these water treatment plants are operating on permits that have expired a long time ago. I don't think this is okay. I mean, I hope I have painted a picture for you of a system that is broken. And so this idea that we're going to let municipalities say yes to new hookups that will promote the tax base and supposedly create affordable housing it's so far from the conversation we need to be having. But there's no question, when you add more sewage to the water treatment facility capacity, when you have releases, you're going to have more sewage going out into the water as part of the overflow. So why would you permit any new hookups right now, regardless of who issues the permit, that are allowed to connect to facilities that are operating under these expired permits? And another example about Rutland, I'm not clear from what you all are talking about whether or not what Killington, I won't say Killington, but the landowner up there, SP Land, they have plans for thousands of new housing units, and that area is served by the Alpine Pipeline, which goes into the Rutland wastewater treatment facility. So could all of that get added in just by municipal approval? It's not affordable housing, but what will this enable? Act 250 has been the effective vehicle to protect water quality from wastewater treatment facility discharges. And a really good example of that is Stowe, where the ski area wanted to increase hookups. That would have resulted in an expansion of the discharge by the plant under normal, not CSO conditions. Through Act 250, it was found that the proposed change in the permit would have resulted in violating the Clean Water Act, changing a swimmable area to non-swimmable to accommodate Stowe Ski Resort. ANR argued the municipality couldn't afford it, but Act 250 issued the permit with the requirements, and Stowe upgraded the plant. Act 250 is our only ability to address these issues in the in any process, because the Agency of Natural Resources does not have a public process. They're not even acting on permits in a way that the public can participate. Later this morning, you're going to be hearing about S112. It has an equivalent in H400. This bill proposes to exempt downtowns from Act 250, which would, combined with this proposed change, result in no opportunity for meaningful public input of the sort that has previously protected water quality, such as in Stowe. The change from state to municipal permitting and the downtown exemption should not be looked at separately, but as a unit. Please delete sections 10 and 11 from S101. If it is going to be considered, please do so as part of an Act 250 bill. There are plenty of real problems to focus on regarding Vermont's water quality. Shifting the responsibility for permitting from the state to the municipality is not even on the list of necessary corrective actions. If you want Vermont's economy to thrive, cleaning up the water is the top priority. Thank you. That's my testimony. I'd be glad to answer questions.
Great. Thank you very much. Senator McCormick.
I was just playing with the screen, but since you've called on me, I guess I am persuaded that the waters are the waters of the state, not the waters of the however many hundred municipalities, and that our municipalities are not in a position to take proper care of the waters. This is not a rhetorical question. I actually, because I preface it by saying I am convinced about the inappropriateness of local management of the state's waters. The state has not done a particularly great job. And if we were to retain state authority, what would either of you recommend we do with that? How do we reform or upgrade the quality of protection being offered by ANR? Because you made a pretty good case against ANR. So.
James, you're muted.
Okay, yes, thank you, Senator. That is a valid point, and I did touch on it to some extent in my testimony, but I can elaborate a little further. I think we need to expand the Act 250 oversight, particularly with respect when it comes to water and water quality. And I also believe that the legislature needs to be actually holding them more accountable on a regular basis. The commissioner of DEC just came before you and Senate Economic Development and all the other Senate committees, indicating that he intended to leave wastewater division positions open and accept a level funded budget. How in the world are we going to ever create affordable housing if we don't have clean water? Because I don't think the definition of affordable housing is housing where the water is so polluted that nobody of economic means wants to live in them. So we'll just herd all of the lower income folks into that housing. I don't think anyone would ever admit to that. So clean water is very much a part of affordable housing and citizen oversight. We have to stand strong against the governor's interest in making this a professional board of developers and centralizing bureaucratic control by expanding citizen control.
And I would add that this is a place where the legislature has an important role to play in holding these state agencies accountable. If they're, I mean, I can't believe some of what I've seen happen in the DEC programs where they're skeletons of what they used to be in terms of staffing. And they're not coming to you saying they need more staffing and they need more money. Have you asked them about these wastewater treatment facility permits and why there are so many expired ones? And just focus on the Otter Creek if you want. And what is going on there? I feel really bad for the Otter Creek. This is why I haven't weighed in on your clean water funding discussions. I don't think that's where the topic should be. It should be on assuring that our water quality is protected through regulation, and the anti-deg rule should be a public rulemaking process where we can weigh in. The permits should be coming up where the public can weigh in. It's very frustrating.
Thank you. Senator McCormick, anything else? If not, Senator, I see
probably
Senator McDonald.
Further down in the discussion, but Senator McDonald had his hand.
Okay, Senator McDonald.
Ms. Smith just brought up LCAR's role. LCAR can, of its own volition, call for, and I will get back to you and on this, but of its own volition can call up rules for review. And any 25 citizens can petition LCAR to bring up rules. As I've just become chair of LCAR once again last month.
Congratulations.
Oh, thank you. The other issue that I was listening to the testimony and I'm going, what happens to citizens when they drive with their license suspended or expired and not renewed? They get busted. And when they do it again, they get busted. And then then they begin to show up on the scofflaws and they get arrested for driving their automobiles without their license. Now I'm sliding Mr. Chair into sort of editorial stuff. But when it comes to the operation of automobiles, we have some pretty darn strict inspections now that you have to pass. They've been promoted by the new car manufacturers who earn a lot of money replacing your brakes every time they get rusty. And the citizenry is expected and obliged to conform to the law when it comes to licensing and operating vehicles that are properly inspected and licensed. And this appears to be an enormous double standard where we have other parts of our society that are obliged to be licensed and to not operate without licenses. And we kind of turn a blind eye to it.
Well, technically, your commissioner will come in and say that they're operating legally because this is what's allowed under the law as long as they have filed an application. That's what's allowed.
And the bill that we have before us is, a product of years of inattention. And we in the legislature will say we got, 4 or 5 other things that are higher priorities. But I will bring it up in LCAR, and perhaps it'll become a agenda item. And if any 25 citizens petition the LCAR because rules have not been written when they are called for in statute, then that becomes an issue that either gets resolved or becomes a point of discussion. So, thank you for your testimony on that one. One factoid, Senator McCormick, I believe that Bethel was mentioned, and Bethel was it had the most recent expiration date. And Bethel, I believe, was the last sewage treatment plant to be built with revenue sharing money. So maybe there's a connection there. After the federal revenue sharing stopped, sewage treatment plant construction declined precipitously.
Mr. Ellers, I see your hand up there.
Yes, sir. One quick comment. I do, and please check with legislative counsel. I do believe that the provision in the law is for an extension for 5 years. That the operation of a NIPDES permit should only be extended 5 years after the application. So again, I could be wrong on that, but I'm fairly certain. And to close on Senator McDonald's analogy, right now we're driving around in a car with bad brakes. And there are members of the Senate who would like us not just to ignore the fact that we have bad brakes, but they want us to step on the accelerator. And I'm hoping that you keep us safe and out of the ditch. And you can count on myself and my allies to continue to support your work to protect our environment. Thank you very much. Best wishes for the hard day ahead of you.
Okay. Thank you for your testimony. I have 5 things flagged in hot pink, which means this is a to-do item now as a result of your testimony. So it's very helpful to have, one of our roles, one of our most difficult roles is oversight, in part because we go away for 7 months of the year. And so it is helpful to us that groups from outside keep an eye on the ball and help us keep an eye on the ball. So we will ask more questions. Thanks again. So obviously, committee, there's more to discuss and more to do. For now, we do have sort of a packed morning and we need to change topic. Senator Polina is here to present a bill. Senator McCormick, last word to you.
Yes.
For the moment.
Just an editorial. I want to thank both of this morning's witnesses for their work this morning and for their work overall. We are in a time where reasonable protection of our environment is seen as an impediment to the well-being and freedom and prosperity of the people. And we've been fighting a rear guard defensive action for many years. And you folks have had your fingers in the dike, and Thank you for your good work.
Thanks so much. And thank you, Senator McCormick, for suggesting Mr. Ellers and Ms. Smith last week when we said, would anyone like to hear from more people? So thank you for that. Great. So with that, we're going to change topics and go to Bill S-112. Ms. Shepherd and Senator Polina are here. Thank you for your patience. I'm sorry that we ran over a little bit on our prior testimony, but we're in the middle of something that was a little intense and important, and we needed a few extra minutes. So good morning.
It's S-44.
Oh, S-44. I'm having a little trouble reading the agenda this morning. As long as everyone else knows what they're doing while they're here, we're in good shape. So, and I'm sure they do. So good morning, Senator Polina. Good morning, Ms. Shepherd. The floor is yours.
Okay. I think that we're going to talk about Anthony Polina, Washington County, by the way, for the record. We're going to be talking about S-44. And I would just say that S-44, while we can say that no bills are simple because everything gets complicated in this building or around these Zooms, I think that S-44 is actually a pretty simple concept. I believe that when it comes to climate change, we're facing an emergency situation, and we need to raise revenues in order to make investments in climate change actions that will help us alleviate the problem as soon as possible. I think we've been pretty good at setting goals in the past and in the present, but we really need to raise revenue to make sure that we can reach those goals. Otherwise, we're going to continue to see ourselves move backwards, which is what's happened a little bit in the recent past. What the bill does is it puts an income tax surcharge on the wealthiest 5% of Vermonters, those folks who I think are most able to afford a contribution to climate actions and actually can do it relatively quickly. According to the Joint Fiscal Office, these folks, the wealthiest 5%, are saving about $237 million a year on their income taxes, thanks to federal tax cuts. So it would not out of the question to ask these people to contribute more back to the state of Vermont. We've done this in the past. 30 years ago, we put a surcharge on income tax of the wealthiest Vermonters in order to have them contribute more to our state economy. So according to the figures from last year, and these obviously may have changed, but according to JFO last year, doing this surcharge would actually raise about $30 million a year. And the $30 million a year would be invested in weatherization, renewable energy, regenerative agriculture, and electric vehicles. It would allow us to meet our energy goals more quickly, our climate change goals quickly, and as well as create jobs along the way. The money would be overseen by the Climate Council that we established last year. And it would be, the numbers, of course, are flexible in terms of where you folks would want to set the surcharge or the amount of money raised, that kind of stuff. But the concept is just that we ask those who can most afford it to contribute sooner rather than later to jumpstarting efforts around weatherization, renewable energy, electric vehicles, regenerative agriculture, so that we can make some serious investments. We need to do more as time goes on, but this would allow us to move forward relatively quickly with raising some much needed revenue. So that's it in a nutshell. I mean, raising money to invest in climate change actions as quickly as possible. And I know we're going to be asking other folks to chip in. We're going to be talking later on this year and next year and the years to come about various fees and taxes that'll be added to energy sources and whatnot. But this would allow us to ask those people who can really most afford it to chip in now and start this process moving as quickly as possible.
Okay. Thank you. It's a very timely discussion. So thanks for your patience in making your maiden appearance in this committee this year, I think, because we spent our first 8 weeks really bearing down on weatherization in a big way, and that led to S-109. Now we're sort of emerging from that and looking ahead at the body of work to be done, which everyone knows there is a lot to do and for decades to come. So, and there are three things that emerged to do more work on. One is the counseling and delivery service. So we really make it accessible to people. Another one is workforce development, to make sure we have people to actually do the work. And the third one, which is going to be the thorniest, no surprise, is going to be the funding. So that's why it's really a perfect time for you to be coming into committee. So I'm guessing you might have wondered why we hadn't asked you sooner, but this was the right time to get up here on stage here. Can you say a little more about the tax cut, and is it time limited? It seems like I remember some discussion about this surcharge that you're proposing might only apply during the period during which the tax cut exists. So I don't know if the original federal legislation was time limited.
It is time limited. I honestly don't remember the timing. And the original bill, or the bill, would say that the tax surcharge would be in place as long as the federal tax cuts are in place. I don't know whether Abby remembers the timing, but I don't want to put her on the spot either. I just don't remember the length of the tax cuts.
Sure, I'd be happy to jump in if you'd like.
Yes,
So
please.
for the record, Abby Shepherd, Office of Legislative Counsel, you are correct, Senator Polina. This is tied to the same date as the Tax Cuts and Jobs Act that was enacted in at the very end of 2017 by the federal government. So this bill, S44, would impose this income tax surcharge until the end of 2025. So it's the same timing as the Tax Cuts and Jobs Act tax cuts.
Okay, great. Thank you.
And just to give you an idea, I didn't mean to interrupt, but just to give you an idea about the savings that some folks are receiving because of the tax cuts. When you look at the so-called 1%, the wealthiest 1%, they're saving on average $33,000 a year in taxes. They're saving $33,000 a year in taxes. A lot of Vermonters would like to make $33,000 a year. These folks that's what they're saving on their taxes. So, and then the next 4% of folks, the wealthiest 4% after the 1%, are saving about $10,000 a year on their taxes. So I think it's not unfair, not unreasonable to ask somebody saving $33,000 a year on their taxes to contribute $2,000 or $3,000 back to the state of Vermont. They're still going to walk away with a $30,000 tax cut.
Right. Yeah. So what is the portion? Can you explain the portion of the how do you proportion it? I mean, is it? It seems like at one point I remember maybe it was former Lieutenant Governor Zuckerman talking about returning half of the surcharge money. What's the formula that you're proposing?
Well, I'm not sure what you mean. I mean, I remember something about the Lieutenant Governor, but it was talking about a much bigger chunk of money being brought back through a heftier surcharge.
Okay.
Well, in talking with the JFO, and this is going back to last year, of course, so it would change, I'm sure. But we talked about having to claw back about 10% of the savings that folks were receiving in order to and we wanted to come back with a number close to the $237 million that the folks were saving. And we ended up with a number that led us to about $30 million a year.
Okay.
I don't know if that's clear or not, but.
Right. Yeah. And can you explain the I guess, Ms. Shepherd, the math, the bill's math in terms of how much we estimate people save, and then how do you calculate how much should be collected in a surcharge?
So I'd be happy to walk you through how the surcharge is imposed, and the structure of JFO is really the does all the magic behind the math. So I wouldn't really be able to walk you through that, but I can tell you how this surcharge would work. If you look at the bill page 4 in section 3, it amends the existing rates. So Vermont has a progressive income tax structure. So it adds another subdivision after you have 5 different subdivisions that split out the rates based on income and filing status. So this language adds in a new rate on top of the existing rates and brackets. It imposes it at 2 different rates. So for individuals whose federal adjusted gross income is between 200 and 500,000, the rate of the underlying rate of taxation, which depending on filing status is either 7.6 or 8.75 currently, an additional 1.6% tax would be imposed. And that's just between 200 and 500,000. For income above 500,000, the rate of taxation would go up by 0.15 on that amount above 500,000. So that would, rather than being an 8.75% tax, it would be 8.9%. And then the income or the revenues raised from this income tax surcharge would not go to the general fund. They would go to this new fund that's being created under the bill, which is the Vermont Green New Deal Fund. And again, that would only be available from, let me just check, this takes effect July 1st of this year, and it would expire. It would all be sunset at the very beginning of 2026, so the end of 2025.
And the estimated revenue that it generates annually is?
I understand is it's around 30 million, but I would
Okay.
recommend that you speak to JFO about how they got to those numbers. That would be Graham Campbell.
Okay, great, thanks. A ballpark is enough to get us started for sure, and we can follow up with Graham if we need more data. Thanks.
Great.
Any committee questions for Senator Polina or Ms. Shepherd? All right, Senator McCormick.
Thanks. Obviously, this tax bill is before the Natural Resources Committee because of where the money would go if we do this and raise it. But I do want to talk very briefly about finance. And Senator McDonald will certainly be dealing with this in the Finance Committee. The argument that's always made against taxing the rich is that just matters of justice and fairness aside, as a practical matter, the rich will leave the state if we tax them too much, that there's a point of diminishing returns, and that in fact they will flee with their money. And I'm wondering if you have any actual information on what the point of diminishing returns is. How far can we push income tax before it starts to alienate the people with the money? And
Well, I
we
would have
lose
to,
revenue.
I'm sorry, I would have to go back and rethink it. We have information. I was not prepared. I didn't bring that kind of information with me today. But I would say in general, the fact is that wealthy people don't leave when you raise taxes necessarily. There's no evidence of that having taken place. There have been a number of studies that have been done that show that it's a fallacy. And there was a big study done in New England states by folks down in UMass a couple of years ago, which looked at all the other studies and said again that there's no evidence that in fact raising taxes is what causes wealthy people to leave the state that they live in, because they live in that state for certain reasons, and taxes are not the reason that they live in those states. We also know that from some work that I think it was JFO did, I forget now, over the last couple of years, that folks moving into Vermont are wealthier than folks moving out of Vermont. That in fact, folks who leave Vermont are the lower income folks who are having a harder time finding jobs and paying for their expenses and their cost of living. Well, wealthier people tend to like being in Vermont because it's a nice place to be. You know, we've got a good educational system, we have a good environment, good quality of life, and people who have settled here and started businesses and raised good income are not likely to get up and leave because their taxes go up a little bit. We also know that states like California and to New Jersey and some in between have raised these taxes, and they have not seen a resulting loss of wealthy people leaving the state. So we could go over that more if people are really interested. We could bring forward some information, but there's really no evidence that people leave a state because you raise the taxes.
My sense is, as I've stipulated, this is not a tax committee, it's the Natural Resources and Energy Committee. But if we present any kind of environmental initiative that's going to cost money, we will be asked how we're going to pay for it. And if our answer is, is this, we're going to have to be able to defend that against that accusation.
Sure.
So I'd appreciate any support you can give us in that regard.
Sure. And I would just say that, we raise taxes. We're worried about whether these folks will leave, but we're probably, if we don't raise taxes, and this is a temporary tax increase, of course, as we mentioned, it's not a long-term thing and it's not a big amount. It's basically just to jumpstart the efforts. But what we'll end up doing, if not, or in addition to this, we'll end up raising other taxes or fees that impact, broad swath of Vermonters, low and moderate income people. And we have to think about the impact on those folks as well. I mean, those are the folks who are talking about leaving Vermont, or the folks who can't afford to live here anymore, not folks who have $1 million and can afford to live anywhere they want to live.
Thank you. Yeah, if at your leisure you can send additional information like that along, that would be very helpful, because I agree with Senator McCormick. Although it's not our job to raise the money, pretty much every time we talk about doing anything for the environment, people say, well, how are you paying for it? As opposed to it being the obligation of the legislature in general to figure that out. But
Sure.
So it's good when we have answers. Thanks. Senator McDonald.
Senator Polina mentioned that 30 years ago, we had a surcharge on high income Vermonters. And that's true, but incomplete. The federal tax rate 24 years ago was, I believe, was 24%. And for 2 years, there was a surcharge put on to eliminate the deficit. And for low income taxpayers, they got a 3% increase from 24 to 27. The middle group went from 27 to a 30% 30% of the feds, and for the high income, it was 33% of the feds. That translated into actual increases in taxes by 12% of federal income tax increase at the bottom, 24% in the middle, and 36% at the top. That was a 36% increase in federal income and Vermont income taxes for those 2 years, and they expired. During those 2 years, the number of people in the top income group grew in Vermont more rapidly than the middle and lower incomes. Now, that was 30 years ago. We have a different attitude and philosophy today. We have different interest groups that are more powerful about taxes. But that's what happened 30 years ago. And that was rather under Governor Snelling and the Speaker Ralph Wright, who sat down and said, this is what we have to do under the circumstances. And that's what happened. When it expired, the rate, I think, went back to 23% of federal liability. But that's Senator Polina perhaps was truncating his remarks, which were accurate but incomplete. That's a kind of a snapshot of that unique time in our tax history.
Thank you, Senator McDonald. It's always good to have the long view on some of these things. I mean, there's nothing new under the sun. So it's good. It's good to learn.
Except for solar panels.
Yeah, right. The other thing too, Senator Polina, that is of interest to the committee is we're talking about not finding a single stream to support a broader work in energy savings, weatherization, cleaner heat, and supporting clean transportation. And so we're looking at a variety of things like bonds, different types of bonds. We are proposing yet another stream that could be tapped. There have been discussions around, we actually already have taxes on fuels. Might they be adjusted based on their carbon impacts? And we're looking at some innovative funding methods like to the meter billing, where a utility actually, the homeowner or renter doesn't take any loan to do the work. The utility actually does the work and is repaid by savings that are built into the bill every month. They get repaid over time. So my hope is that we assemble a collection of tools, and then we don't have to lean on any one thing so hard. And then my hope is that makes for a more reasonable package all the way around, as opposed to the silver bullet, which could be a very expensive silver bullet. So thank you for adding another piece to the discussion and the work of the committee.
Sure. I mean, I don't envy you. You're dealing with a huge problem, and it's going to be costly, obviously, no matter what route we take. But on the other hand, if we don't do something, it's only going to get more expensive. As you well know, you've been grappling with this for years. So, and I think that putting something like this into the mix is not going to be particularly burdensome for anybody. It's going back to what Senator McDonald was talking about. We're talking here about a fairly small surcharge on a group of people who can very much afford to contribute more. So I appreciate what you're trying to do. And I think that what I'm looking at is a way to do it in a way for asking those who can afford it to pay more, and something that we can implement and reap benefits from relatively quickly. In making it temporary, it means we jumpstart the effort, and then we don't have to continue to burden these people in the long term.
Great. Well, thanks so much. Anything else that you or Ms. Shepherd thinks we ought to hear while you're visiting with us to tee this up?
I don't think so.
Okay. Committee, any other questions for Senator Felina?
I would remind you that most of you sponsored this bill like this last session.
Yes.
Look in your files.
Yes. Yeah. It seems rather familiar to me. And to your remark about that knowing that something's costly and it's going to take years of work to do, you came in on the end of a testimony related to water quality work, which is very similar in a way. I mean, we have public health impacts. We're talking about climate and air impacts here, and there we're talking about water impacts, and these are all essential resources we all rely on. And whenever we underfund, we perpetuate problems.
Yes.
Okay.
Well, I trust you'll come up with something that works.
Well, we appreciate that trust, and
it might take a while, but
we'll keep working. We make incremental progress. I think everyone wishes we could go faster.
Sure.
We're falling behind.
Yeah. Well, right. And there's some areas where I'd say the prior testimony was showing places that I think are in retreat, not advancing. Okay. Well, with that, thanks very much for coming in. And
sure, no problem.
We're gonna check and see if Ellen is available to go to teeing up another bill that just arrived. Well, this one just arrived in our committee, S119.
No,
right.
She's not available yet. She's still in Ways and Means.
Okay, so committee, why don't we take a 10-minute break? If she's not here by the end of that, I'll do a brief walkthrough without Ledge Council of the bill related to establishing a community energy program. And the nice fit for us is this is a bill we've had in committee for 3 years running. It was basically says, could we do renewable energy, very most likely solar, at a larger scale, thereby bringing the cost down and make it more affordable for people to sign up for, make it more affordable for utilities to purchase. And right now, the governor has a proposal in to do low-income renewable energy, probably solar. So by the addition of a low-income section to this bill from a prior year, we might be able to tailor something that's a good fit for money that's available right now. So today I just wanted to get it on the table. And I think in the next several weeks, if the committee's interested in that low-income renewable energy proposal, that this bill could be a vehicle for getting that out with pretty promptly, actually, would be my hope. Okay. With that, it is 9:47.